Welcome to the class. In last class, we are discussing part 5 of the Constitution. Already I have discussed Article 52 to Article 100. In the previous two lectures are there. In the channel, you can watch that before watching this lecture. In this class, we will discuss Article from 101 to, let's say, Article 123 in detail. First, Article 101, it says vacation of seats. It says no person shall be a member of both houses of the parliament. There are two houses actually. We have Lok Sabha, we have Rajya Sabha. So you can be MP of any one of these things. For example, you contested for both seats, Lok Sabha and Rajya Sabha, and you won both. Then you have to vacate one of the seats. You have to vacate one of the seats. Actually, let's say you became Lok Sabha MP and Lok Sabha MP and Rajya Sabha MP. Then within 10 days you have to inform. Otherwise, the Rajya Sabha seat will become vacant automatically. This is as per the uh, rules of the parliament. No person shall be a member of both houses. If you are so, then you have to vacate any one of the house. Otherwise, the Rajya Sabha seat after 10 days, it will automatically become vacant. Let's say you are sitting MP. You are sitting MP. This is first condition. You are sitting MP and you are contesting. Then, if you won for other house, you are sitting MP, let's say in Lok Sabha, and you are contesting for Rajya Sabha, and you are winning. Now you are holding Lok Sabha and as well as Rajya Sabha. So in this case, you have to inform again. Otherwise, the previous seat, that is this seat, will become vacant, and you will automatically become Rajya Sabha. You have to inform to the authorities. And then this is second case. Then there is third case. If you are both Lok Sabha, let's say Lok Sabha MP in two constituencies, then you have to exercise the option for one of them. Otherwise, the both will become vacant. So this is described here. So no person shall be a member of both houses. If so, you have to intimate within 10 days, or else Rajya Sabha seat becomes vacant. If sitting MP elected to other house, then first house becomes vacant if not intimated. If two seats in a house, let's say in Lok Sabha, you won from two places, two constituencies, then you have to exercise option for one. Otherwise, both will become vacant. So that is Article 101 Class 1. Then 102 says, Class 2 says, no person shall be a MP as well as MLA or MLC, whatever. MP means here Lok Sabha, Rajya Sabha, MLA or MLC. You cannot be members of these things at the same time. And within 14 days, you have to intimate the authorities. Let's say you are MLA and you won as MP. Then within 14 days, you have to inform. Otherwise, the MP seat will become vacant. This is explained here. If you are both MP or MLA, within 14 days, parliament seat becomes vacant. Means within 14 days, if you not inform, or unless you resign the MLA. Let's say you are MLA and you become, you contested MP as you won MP. Then let's say you have not resigned this MLA post. Then after 14 days, this MP post will automatically go after 14 days. So no person shall be a member of both houses. That is first one. And no person shall be both MP or MLA or MLC. Then 3A says, 3A says there is disqualification. There is disqualification. This is as per Article 102 Class 1 and 102 Class 2. 102 Class 1, 102 Class 2. So 102 Class 1, 102 Class 2. This 102 Class 1 says, 102 Class 1 says, the president can disqualify. 102 Class 2 says, this is the 10th schedule. This is 10th schedule. This is disqualification. This we will discuss. 102 Class 1, president can disqualify on certain grounds. And then 102 Class 2 on 10th schedule, that is anti-defection law, you can be disqualified under some under some conditions. Then you can also resign as MP. However, this resignation letter as MP you have to give to the speaker if you are Lok Sabha MP, or chairman if you are Rajya Sabha MP. You have to give resignation. However, the speaker or chairman will verify that resignation whether it is voluntary or not. If it is voluntary, then only they will accept. If it is forceful, for example, I am forcing one MP, you just resign. Then they will check, speaker, chairman, they will check whether he is resigning voluntarily on his own or someone forcing. So if someone is forcing, they may not accept, and they will not accept the resignation of the MP. Then 101 clause 4 says if you are absent for 60 days without permission, then you are automatically ending as MP. So these are vacation of seats, means when you are when you have to vacate your seat. Let's say you are MP and now you will be vacated your seat in these cases. In these cases, if you are both houses of MP, you have to choose one. Otherwise, you have to vacate in one of the things. If you cannot be MP MLA at the same time, then you can be disqualified by president also under 10th schedule. That is disqualification. Of course, you can resign also. If you, then you have to vacate. Then if you are absent for 60 days without permission, then also you have to vacate your seat. However, this calculating 60 days, if more than 4 days consecutively it is adjourned, house is adjourned or prorogued, okay, adjourned or prorogued or adjourned, then this you will not count. This only some small fact to remember. Then these are the mentioned in the constitution. Then other than constitution, election may be declared void as per the RPA Act. Then you have to go to High Court for through election petition. Then appeal is lies in Supreme Court. Then you may be expelled by House also. Let's say you've done something wrong. Then House, there are various motions. Okay, there are various committees, ethics committee. There are many committees which can be members can be expelled if you are doing something unparliamentary. You spoken something. Okay, then you may be expelled. Then you have done misconduct, then also you can be expelled. Also, if you become vice president, vice president or governor, okay, then also automatically your MP or MLA seat will become vacant. So this is 101 vacation of seats. Then 102 disqualify. I told here under 100 class 2, 102 article 102 class 1, president can disqualify if there is office of profit. If you are holding any office of profit, let's say you are MP and you are also working as government servant, then you will disqualify. Then you are unsound mind. This should be declared by the competent court. If you are unsound mind, then you are insolvent. Let's say your debt means arrears is greater than your assets. You have very less money, but you have huge debt with you. There is crores and crores debt in that case also. And then you are not a citizen of India, or you acquired the foreign citizenship, or you showed some allegiance, loyalty. Let's say you showed loyalty to some country, okay, or you are acknowledging that country's loyalty or allegiance, or you are sticking to that country. So in that some cases, the president can disqualify. Okay, being MP, you must support India and you must be a good Indian. You should not acquire any citizenship of other countries. In that case also you can disqualify. Otherwise, any law made by the parliament. So for that, parliament made RP Act 1951. So that is given here. President here 102 class 1, president can disqualify. Office of profit, unsound mind, insolvent, not citizen or voluntarily acquiring any citizen, or showing allegiance or adherence. Law of Parliament made RP Act. Then 102 class 2 10th schedule. Here speaker will decide the matter. This is given in 10th schedule. This is anti-defection law. 10th schedule is related to anti-defection law. This is anti-defection law. This is added by 52nd Constitutional Amendment Act 1985. That time Rajiv Gandhi was the Prime Minister. That time it is added. So this 10th schedule mainly, for example, you contested from party 1. Okay, you won election. Okay, now you are shifting to party 2. You resign party 1, you shifted to party 2. Okay, this was happening that time. So people thought, okay, because this party 2 is giving some money to him, so he is going to that party. So this should not happen. So that's why anti-defection law has been brought out by through Constitutional Amendment Act, 52nd Constitutional Amendment Act. That is 10th schedule. So here in 10th schedule, let's say there are some conditions. If you are voluntarily resigning, okay, from the party, if you are voluntarily resigning from the party, you will no longer become MP. You have to vacate your seat. Okay. And then let's say there is a whip given by the party, political party, your party. For example, you are from Congress. So Congress given whip means some command. For example, you have to vote like this. Some bill is there. You have to vote like this, or you have to say like this. So then that whip is not following that person. Okay. Then of course, if the party in 15 days it is forgiving him, pardoning him, that's okay. Otherwise, he has to vacate his seat. Then, if you are independent member, you cannot join any political party. Otherwise, your MP seat will go. Then fourth one, if you are nominated a person within 6 months, you must join any party within 6 months. After 6 months, you are joining, you have to resign from the MP seat. So in these 4 cases, your seat will become vacant under 10th schedule, that is anti-defection law brought out through 52nd Constitutional Amendment Act 1985. Of course, there are some exemptions for this. There are some exemptions for this 10th schedule. For example, if speaker is resigning from the party, you remember, from party is important. From any political party, he is resigning. He will not, this 10th schedule will not apply to him. Of course, he can rejoin the same party. He cannot join the other party. That is not allowed. He can resign and he can say independent. Of course, he can again rejoin the same party. He can rejoin same party. Then also it is okay. For speaker, this is the power given or exemption given. Also, if 2/3 of the party, some party one say 2/3 of the people are going out, then it is allowed. Means some problem in the party. 2/3 means it is huge number. There are leaving some party, means that is a problem. So they can join any other party, or they can remain independent also as a separate party. So in that case also it will not apply. This 2/3 exemption will also not apply. This is 102 disqualification for membership. So here president can disqualify. This is given in article 103. Okay, just a minute. This is given under article 103. So article 103 we will see. Then 100 here there is disqualification law made by parliament. So these some conditions are there. You see in section 8. Here we have seen 100 to disqualify any 100 to what we have seen 100 to any office of profit you are holding other than MP seat, then you will be disqualified as MP. If you are unsound mind, then also you will be disqualified MP. If you are insolvent, then also. If you are not citizen of India or taking other citizenship, so then also you will be disqualified. Or any law made by the parliament. So parliament made this law, RP Act 1951. So here it is given, if you are doing any conviction for certain offences, your court has given you some criminal charge, then you have to vacate. This is given. What are those offences means? Like dowry, etc. Dowry, child marriage, untouchability, those offences. Then section 80A 123 of the RPA Act 1951 given any corrupt practices or electoral offences. Electoral offence means election offences. Like you both capturing, Okay, or you are voting, doubly voting, like that, tooth capturing, all that, or bribing the voters, you are giving money to the voter, that is also election offense or electoral offense. Then corrupt practices you are doing, bribing, etc. Then section 9 says any corruption or disloyalty you have dismissed. Let's say you are government servant, you dismissed from the government servant as government servant because of some corruption charges. Then you cannot, you will be disqualified. Then section 9A, section 10 are office of profit. So there is some contract, government contract with you. Also some government company you are involved, some office of profit you are involved. Then section 10A, you have not given election expenses to the election commission as per sections 10A. So under these conditions also, you have to vacation of the seat is there as per article 101. So this is given in 102, sorry, disqualify. Okay, this is disqualification as per article 102. This is given 102 1E, 102 1E. That is, this is law, RP Act. Then 103, I told this is related to disqualification. So president, as per 102 class 1, president can disqualify. Okay, if there is any office of profit or your unsound mind declared by the competent court. Okay, if you are insolvent, that is your debts are more than your assets, then you are not a citizen or acquired foreign citizenship or showing loyalty to the foreign citizen, foreign country, or any law made by the parliament. So here RP Act 1951 made here section 88A, 99A, 1010A. Some offences are given here. Of course, article 123, sorry, section 123 also given some electoral corruption practices. So this is decided by the president. This is given in here. So disqualification question as per 102(1), president will decide and his decision is final. Of course, when deciding this, president will take the opinion of the election commission. And okay, president will refer to the election commission. Sir, what election commission, Mr. Election Commission, what you will say? So whatever election commission say, that president is will doing. So it is a binding on the president. It is binding on the president. Binding must follow that. That is 103. Then 104, for example, there is penalty of rupees 500 per day. In the 104, let's say you are not disqualified by MP. Let's say you you contested for MP and you by fraud or something you contested and you won and you are sitting there in parliament. Then you will be imposed 500. That is only if you are disqualified. Here given. Okay. For example, you are not taken oath. Okay, not taken oath under article 99. 99 is the oath of members. Or when you are not qualified, or when disqualified. Let's say you are MP. Your government disqualified you, still you are going and sitting there. Then also, if you are prohibited from any law made by any law. So in these cases, if you are going and sitting again in the parliament, okay, that is the problem. They will impose the penalty 500 per day. Then article 105, powers and privileges to the houses of the parliament, to the houses, members and committees. Houses. So houses means Rajya Sabha, Lok Sabha. Members means MPs in that. And committees means here parliamentary committees are there. For them there are some powers, privileges. Why these powers, privileges means to perform their duty. If anyone saying something against the parliament, it will reduce the dignity, credibility of the parliament. So we should not criticize these things. So if you are criticizing, it is like you are breaching their rights. The house will, there is contempt of house will apply. Contempt of house. This is for the house. Contempt of house means, contempt means like it got angry. House got angry. Let's say you are obstructing MP from not going to parliament. You are obstructing him. You are not making him to attend the parliament sessions. Then it is like your dignity, authority of the house you are reducing, or of the members you reducing, you are obstructing them from their duty, so it will raise to the contempt of house, and it is punishable. It is punishable. Similarly to members, members means here MPs, we are doing something to them, so it is also, it is like their rights or anything is going on, then this is breach of privilege. So there are two things: breach of privilege, contempt of house. Breach of privilege means any rights, their privileges you are stopping. Contempt of house means you are obstructing them, means blocking them. Okay, then it is punishable and it will attract contempt of house. These things you cannot do. Okay, so that's why 105, Article 105 guarantees some powers, privileges to them. So first privilege is that there is a freedom of speech in parliament. There is freedom of speech in parliament. Means you can freely speak out. You can freely speak out whatever you want. You no need to any pressure force, you no need to undergo. Then whatever you said, whatever you vote, you cannot that is freedom is there, and you cannot be inquired in any court, no case, nothing will be there. And also for the house there is a publication, freedom of publication, any report or paper or votes proceedings you can freely publish, you can freely publish. Then whatever defined by the parliament, other privileges as defined by the parliament. Then these privileges, okay, will also apply to those persons who have right to speak or to take part in the proceedings. For example, attorney general is can take part, can speak up. Okay, however he cannot vote. So these privileges will also apply to attorney general. Of course there are ministers, they can also right, they can also have right to speak and take part in the proceedings. They can go to any house and they can speak, they can take part in the proceedings, they can listen what members are saying. So ministers also enjoy these privileges. So MPs will enjoy, of course ministers will enjoy, of course attorney general also will enjoy. These are 105. There we can classify these privileges into individual privileges, means it is for MPs. So they cannot arrest 40 days before, 40 days after the session. Let's say there is actually 3 sessions we will be having: budget session, monsoon session, winter session. Let's say budget session here started, budget session. Okay, so 40 days here you cannot arrest, 40 days here you cannot arrest. Okay, so this is the power given to them. Okay, immunity or rights or privileges given to them. Also they exempted from jury service, means you cannot call them to give evidence. MP, Mr. MP, you come, court cannot call them, you give evidence when parliament is in session. Means for example budget session going on, you cannot call MP because he is busy in attending session and working for the people, policies making, everything, discussion. He is very busy, you cannot call, you give evidence like that. Courts cannot call. That is the privilege given as per law. Then there are collective privileges, means it is enjoyed by the house, that is Rajya Sabha or Lok Sabha. So it has right to publication, we already seen, it is given in the constitution directly. That however it was also having the prohibit to others from publishing. However the 44th amendment restored this freedom of the press. Now press also can publish whatever the proceedings, but that should be true. Okay, however this is not applicable in case of secret sitting. So there is secret of sitting of the house also. Sometimes any urgent matter is there or any national security issue is there, at that time secret sitting will be there. Then you are going by some other means and you are recording that and you are publishing, that is punishable. That you cannot do. Secret sitting you cannot do. Normal proceedings, yes, that too you have to report truly whatever happening exactly. And other privileges are, you have to intimate any arrest. For example, you are arresting MP, you have to intimate the house. House means Rajya Sabha or Lok Sabha. You have to intimate, sir, Rajya Sabha, we are arresting this your MP, Rajya Sabha MP, for this crime. Okay, and no person, either a member or outsider, can be arrested. Whoever it is, a member or outsider, nobody can be arrested within the precincts, means within the compound of the parliament. without the permission of the presiding officer. That is important. So you can take permission and you can arrest. Without permission, you can't arrest. Then breach of privilege, I told. This is available for MPs' houses. Whether they have any privilege rights, you cannot immunities, you cannot breach. Contempt of house means you are obstructing the working or blocking them from functioning. That is contempt of house. So breach of privilege, contempt of house. Then 106 is given salaries, allowances of the members means here MPs, members of parliament. So this is determined by the parliament. Until then, constituent assembly was there before our independence or before our constitution. There was constituent assembly. So those members, whatever the salary allowance they getting, these MPs also will get same things. And then this is determined by parliament, I told. So there should be law. So 1954 there is MP Act, MP salary of MP Act came. This also there was no provision in pension in the constitution. However, Parliament has provided for this pension to the MPs. So that is 106 salaries of the members. 106 salaries of the members. Article 75, it given minister's salary. Minister's salary. Then Article 97, salary of chairperson, deputy chairperson, speaker, deputy speaker. 106 MPs. Then 107, provision as to introduction and passing of bills. It is related to bills. First thing, it may originate in either house, that you remember. Any bill except money bill, financial bill. They have to go first in the Lok Sabha, that is House of the People. Except money bill, financial bill, any bill can originate in either house except money bill, financial bill. And a bill becomes the act only when both houses should pass it, except in case of joint sitting or money bill. Then a bill does not lapse on prorogation of the house. Prorogation means, in last class I discussed, ending the session. Prorogation means ending session of parliament. That is prorogation of the house. So that time the bill does not lapse. Let's say there is upper house, we know, Rajya Sabha, lower house, Lok Sabha. So a bill pending here will not lapse on dissolution of the House of the People. On dissolution of the House of the People, bill does not lapse. Okay, you are dissolving the Lok Sabha, so there is no way related to bill here. So I am introducing the bill, and the bill is pending in the Rajya Sabha. That will not lapse. That is 107. This 4, class 4. And then let's say I have introduced the bill in Lok Sabha. That will lapse. Let's say I have introduced a bill in Lok Sabha and it went to Rajya Sabha also after passing here. This also will lapse. This also will lapse. Then a bill which is, this is what I told, a bill pending in the House of the People, that is Rajya Sabha, Lok Sabha, or which having been passed by the House of the People pending in the Council of States. Okay, subject to joint sitting, it is lapse on dissolution of the House of the People. That is what I explained simply. And then also this is given in the Constitution. This is given in the Constitution. These are extra. President, if notifies the joint sitting, then you cannot go. Then President assent is pending, then also bill does not lapse. Then President is returned the bill for reconsideration after both houses passed. Okay, then in these cases the bill does not lapse. In those cases, bill does not lapse. So 107 related to bills. 107 related to bills. What it says first, it can originate in either house. Both houses should pass. Of course, there is exceptions. Both houses should pass. Again, for these exceptions. Then if you are prorogue the houses, you means here president. If president prorogue the house, the bill will not lapse. Okay, no lapse of the any bill. Let's say you are dissolving the Lok Sabha. This is also done by president only. Then if any bill pending in Rajya Sabha, it will not lapse. If any bill pending in Lok Sabha, it will lapse. Any bill Lok Sabha passed, it is pending in Rajya Sabha, that also will lapse. And these are extra. If president notified joint sitting, then will not lapse. President assent is pending. That's okay because Lok Sabha passed, Rajya Sabha passed. Now it is pending with for the president. You may be knowing first bill is introduced any house, Lok Sabha, Rajya Sabha. Of course, some exceptions are there. Let's say it is introduced in Lok Sabha, then it will go to Rajya Sabha. Then president has to sign. That is assent he has to give. Then the bill becomes the act. This is the procedure. Then 108 joint sitting. 108. This is wrong. This is wrong. Joint sitting. So joint sitting is, let's say one bill is passed by one house, Lok Sabha, or it is going to Rajya Sabha, and this Rajya Sabha is rejected it. Okay. Or there are amendments which both are not agreeing. Or one house is passed the bill, other house more than 6 months is there, but no action has taken. In these cases, only 3 cases, joint sitting will happen. Only 3 cases, remember. The other house is rejected the bill, or with respect to amendments there is a disagreement, nobody is agreeing. Okay, Lok Sabha say yes, Rajya Sabha say no. Rajya Sabha say yes means Lok Sabha say no. Or other house, one house is passed, it went to other house. Then more than 6 months it is pending with the other house. The other house is simply watching the, no action is taking. Then president will message if they are sitting. Otherwise, public notification if they are not sitting. A giant sitting. Except this will not apply to money bill. We will see it. So president will call for the giant sitting in these 3 cases. If they are in session, means any budget session, monsoon session or winter session is going on, he will send message simply, SMS he will do. SMS means not SMS, he will message the members. Otherwise he will issue public notification. Okay, on this I am intending to joint sitting to remove these disagreements. So that is 108. Then for 6 months to calculation, for calculation if house is adjourned or prorogued for more than 4 consecutive days, that will not count. Then president once notified neither house, you cannot proceed further with the bill. We will also once notified joint sitting president, you should not touch the bill then. You should not discuss the bill any further. Only after coming to joint sitting, then you have to keep the bill aside. Once president notified his intention, that is very important. Once president notified, neither house shall proceed further. That is very important. Then you have to pass. Now joint sitting you have come. You have to pass that bill with a simple majority. Means 2/3 of the members. Sorry, 50% plus 1. 50% plus 1. That is present and voting. 50% plus 1 present, that is simple majority. Then there are some provision, means some condition, some terms. No amendment, let's say bill passed by one house but not written by the other house. In that case only no amendment is allowed. Only amendment necessary due to delay, maybe some date change is there, something like that. Only those amendments will allow, other amendments will not allow. If the bill passed by the other house and it is coming to the it is passed by one house and it is returned by the other house with amendments, okay, then only those amendments which there is disagreement, that you can discuss, plus any amendment related to delay, that you will allow. However, whether these amendments will should be allowed or not, that is again decided by the presiding officer, that is speaker or chairman or the person acting such. That is presiding officer. He can be speaker, maybe speaker, let's say that day absent. Then some other person is presiding that house. So that is Article 108. Then 108 further says, even if Lok Sabha dissolved, let's say president notified the joint sitting. Okay. President notified joint sitting here. Let's say Lok Sabha dissolved here. Even then, new Lok Sabha when coming, joint sitting will be there. That is, the joint sitting still take place. Once after notified, even Lok Sabha dissolved, and let new Lok Sabha come, then joint sitting will be there. So joint sitting will not end, even if Lok Sabha dissolved. This is only once the president notify. President has to notify after that only. Then 109 special procedure in respect of money bills. So this is very easy. Actually, money bill, this is related to financial matters. This is given in Article 110. Okay, if any of those provisions there, that is money bill. That is called money bill. So if money bill is always introduced in Lok Sabha. After Lok Sabha, it will be transmitted to Rajya Sabha for recommendations. For not for passing. Only recommendation has to give Rajya Sabha. Okay. That is the first thing. Then Rajya Sabha, within 14 days it has to send the bill, return the bill. So Lok Sabha sent the money bill to Rajya Sabha. Let's say Rajya Sabha sent some recommendations. If Lok Sabha accepted, the bill passed with such recommendations. If Lok Sabha not accept no such recommendations, as Lok Sabha how it sent originally, in that form it will send. In that form it will it is like passed. Let's say 14 days finished. Okay, Lok Sabha not written the bill. Rajya Sabha not written the bill after 14 days also. Then whatever the form in Lok Sabha sent, that form it will be passed. The bill will be passed. So Rajya Sabha, it is having no role at all with respect to money bill. It just has to give recommendations. That too within 14 days it has to give. And Lok Sabha may accept or may not accept. If Lok Sabha accept, okay, those recommendations will be added in the money bill. Otherwise, those recommendations will not be added in the money bill. So that is given. Money bill shall not be introduced in the Council of States, means Rajya Sabha. Lok Sabha, then money bill after passing in Lok Sabha transmitted to Rajya Sabha. Then for its recommendation, then within 14 days, Lok Sabha within 14 days it has to send. Then if Rajya Sabha sending within 14 days, then Lok Sabha may accept, may reject. If Lok Sabha accepts, those recommendations are added. If not accepted, those recommendations are not added. If not written by Rajya Sabha within 14 days, as Lok Sabha, whatever the form it has sent, in that form the bill deemed to be passed. That is 109 special procedure in respect of money bills. Special procedure in respect of money bills. Then 110, this is definition of money bills. What is money bill? So a bill is considered money bill if deals only, very important, only the following, any or all of the following matters. If any of these matters are there, then only it is called money bill. For example, any taxation matter. You are impose new tax. Let's say now government has to impose GST. Then new law has to come. For example, for imposing GST, there is CGST Act. Because of this only we are paying GST, or Income Tax Act is there. So if you want to make that, these are money bills. Okay, these are money bills. When bill introduced, if you want CGST bill is introduced, it is introduced as a money bill. In that case, Rajya Sabha no role, zero role. So any tax I have to impose or abolish means remove, or remission means change, alter, regulation. Regulation means how it is imposed, how it is collected, everything rules, everything is all tax matters that is comes under the money bill. Any tax matters, one bill is introduced, only tax matters, for example, only or any of these provisions. And then regulation of borrowing of the government. Let's say government has to bring loan from some other country. So how it is done? Or government has to borrow from RBI, borrow from someone. So then you have to introduce the bill, and as per that bill only, that regulation, that borrowing will be regulated by money bill. Then custody of the consolidated fund, contingency fund, payment of monies into that fund, withdrawal of monies into that fund. So here custody, payment, withdrawal of two funds, consolidated fund of India, contingency fund of India. Okay, consolidated fund, contingency fund. Okay, that is also anything related to that is coming. That is also money bill. And then any appropriation you have to do. Appropriation means you have to withdraw from consolidated fund of India. Then also you have to introduce that bill as a money bill, or declaring any expenditure as a charged expenditure. C.E. Charged expenditure from consolidated fund of India. That also, or you have to increase that. Okay. Let's say now Lokpal is there, or national chairman of National Human Rights. His salary is a charged expenditure. You have to declare that, means you have to introduce money bill. Let's say the chairman UPSC, his expense is salary expense is already charged expenditure. Now you have to increase his salary. Then you have to introduce that as a money bill. Then receipt of money. Uh, then receipt of money, custody or issue or audit of two funds here: consolidated fund of India, public account of India. These again related to these again related to money bill. Then any of the matter of incidental to A to F above, this all defined as a money bill. So only all or any of these provisions are available, that is only money bill. So what is not a money bill? So here what is not considered, for example some fines, for example you driving, traffic police imposes some fine, no, that is not a money bill. You cannot, for example I want to collect 10,000 rupee as a fine from the traffic violators, so that bill is not a money bill. So any fine you are imposing, that is not a money bill, or any penalty. Okay, any fees, license fees, etc., or service fees, any service fees, or any tax imposed by the local authority. So these things are not a money bill. These things are not money bill. Then if any question, what is a money bill? If any question arises whether it is a money bill or not, the decision of the speaker is final. For example, Aadhaar, it is not at all related to money bill, but government passed this as a money bill. Okay, who will decide whether bill is a money bill or not? Speaker. This is important question. Who will decide the bill is a bill, money bill or not? That is the speaker, and his decision is final also. Nobody can question, even court. Then when here what happens? Rajya Sabha upper house, Lok Sabha lower house. So when money bill is passed, is transmitted to Rajya Sabha, speaker has to endorse it. Speaker has to endorse it. Endorse means simply he has to sign. Oh, it is a money bill. Like that, speaker has to sign. That's all. And when money bill is sent for the signature of this president, okay, then the speaker has to give the certificate to that extent. Certificate means separate letter he has to write. Sir, Mr. President, sir, this is a money bill. Like that. Then assent to bills. Bill is introduced in any one house. Okay, house 1. Then it is going to house 2. Then it is going to president for the signature. Here president can have 3 options. He can sign it. Okay, or he can withhold assent. Means he can reject it. or he can send for the reconsideration. Once he can send to the houses. Once, this is once only. So he can sign, means he can give assent. Okay, I am signing. Like, then he can withhold. No, not signing. But he can send back for reconsideration. So he can give assent. He can withhold assent. He can send for reconsideration. But once it is passed again to the president, then he cannot not withhold assent. This is not for money bill. Money bill is, I already told. For money bill, president will sign. President will sign money bill. Because money bill is introduced with the recommendation of the president. So these are the three options he having. So these are actually called veto powers. Absolute powers means he is withholding his assent. That is rejecting the assent. That is absolute veto. Suspensive veto means when president is sending back the bill once, he can send maximum once only. But once it is coming back, he must assent or he shall not withhold. Then pocket veto means simply putting in pocket. A bill is coming, president is not signing, not rejecting, not accepting. He is simply putting on his table indefinitely. Okay, simply that file is with him on his table. No action is taken. That is packet veto. It is like simply taking and putting in packet. Then qualified veto is, this is available to US president, not our Indian president. Here what happens, when president is returning the bill, then houses should pass this bill with special majority. For example, here simple majority they earlier passed. Now they have to pass more than that simple majority. That is special majority. Now they have to pass. Then it is a qualified. There is some condition. So that is qualified veto available to US president. This is not our Indian president. Is not available. That is 111, Article 111, assent to bills. Then annual financial statement. This is budget. So this budget is word is not in constitution. This is the important question. So who will cause budget to be laid on both houses? President will cause. This budget is a statement of estimated receipt and expenditure. Estimated receipt and expenditure. Receipt means whatever your income. Expenditure means whatever your kharcha. That is called annual financial statement. And this here we have two estimated receipt, estimated expenditure. Income, expenditure. So this expenditure is divided again to one is charged expenditure, another one other expenditure. And then what is charged expenditure? It is given. Charged expenditure means the president, his office expenses, salary, etc. Then chairman, deputy chairman, salary, speaker, deputy speaker, salary, and his office salary, all these things. Then debt charges of the government of India. Let's say government has to pay something to the USA. Then it is coming as the charged expenditure. Then Supreme Court, salary, pension. Salary plus pension. Then federal court, now federal court not there, so only pension. For high court, pension. Sir, what about salary? Salary is given by the state from consolidated fund of state. This is important. Salary. Then Comptroller and Auditor General, his salary, allowances, etc. Then to satisfy any judgment, let's say one judgment came where government of India has to pay 1 crore to some victim. Then government has to take it as a charged expenditure from consolidated fund of India. Then other expenditure declared by this constitution. For example, UPSC chairman and his expenses declared as the charged expenditure in the constitution. That is Article 322. Article 322, expenses. Then Parliament may by law declaring, for example, through any act, Parliament is declaring his salary or his office expenses charged expenditure. So what is the advantage of declaring charged expenditure? Why charged expenditure it is declared? So what is the reason means? This is given here. So procedure in Parliament with respect to estimate means here charged expenditure, there is no vote. You cannot vote, you cannot be given vote, but you can discuss. See what is that meaning means. So whenever for example salary of president is introduced. Salary of president is some rupee X. This is introduced in house 1 or in house 1 or house 2 in houses, for example. Then they cannot vote if it is a charged expenditure. Okay, for example, the bill is defeated. Let's say no, we will not agree like that. Then it is like becoming like you are not able to give salary to the president itself. So that's why this is declared as the charged expenditure. But you can discuss it. You can discuss it. You can discuss whether you let's say you discuss and you disagree also, no issue. But voting will not be conducted. Okay, there may be negatives also more. Still, no voting will be there, and it is automatically like it is passed. Then, however, other expenditure which is introduced as a demand for grant. So that whether to accept or refuse, that is with the House of the People, that is Lok Sabha. Here, what is the meaning? So here, many ministries is there: Ministry of Education, Ministry of Health, Ministry of Defense. So they need money. For example, defense, they have to buy weapons. They need money. Health, any policy is there. Okay, Ayushman Bharat policy, for example. Education, there are government schools, their books, staff, salary, teacher salary. So this everything, they need money, no? That is coming as a demand for grant. That is other expenditure. This is provided as the demand for grant, and whether this should be agreed or not, it is ultimately Lok Sabha having power. No role of Rajya Sabha. And no demand for grant shall be made except on the recommendation of the president. So recommendation of the president is required. So 113 very important. So charged expenditure, no vote. You can only discuss. Other expenditure, you have to submit as demand for grant. Every ministry, and only accept or refuse power is given to only Rajya Sabha. That is House of the People. And no recommendation, no demand for grant can be made except on the recommendation of the president. Then 114 appropriation bill. Now here you declared charged expenditure, other expenditure in 113. Okay, there is charged expenditure, there is other expenditure. Other expenditure means demand for grant, DFG, demand for grant. So now this you have to withdraw from the consolidated fund. So there is account of the center, that is Consolidated Fund of India. So from here you have to take consolidated charged expenditure and demand for grant. So you have to, Parliament has to pass appropriation bill. Parliament law is needed. You simply can't take. If it is your account, you have to go and sign. Nobody can take now. Similarly, from Consolidated Fund of India, Parliament is the authority, highest authority. It has to pass law. That is appropriation means withdraw. This is important. Appropriation means withdraw. Appropriation bill has to be passed. So to meet demand for grant and then charged expenditure. Charged expenditure means I told no voting will be there, only discussion. Demand for grant, Lok Sabha either accept or refuse. No role of Rajya Sabha. Then in appropriation bill, when you are introducing the bill, after introducing the bill, then you cannot vary or you cannot alter destination of the demand for grant. Means let's say earlier you said 100 crore. No, now you are saying 150 crore. No, you cannot vary the amount. Then alter the destination of the DFG, demand for grant. Destination means earlier you saying it is for books. Now you are saying it is for some other purpose. No, you cannot alter that. Also charged expenditure, you cannot vary amount. For example, now you are saying 5 lakhs for the president's salary. Now you are saying after introducing bill it is 20 lakhs. No, you cannot allow. You cannot vary. Before only you discuss under 113 when you are introducing. When you are discussing, you are voting, that time only you have to tell. After introducing appropriation bill, no way. And no money shall be withdrawn except this appropriation bill from the Consolidated Fund of India except under appropriation. So Parliament has to pass the law. Okay, this account is very powerful, very strict. Parliament is need law to take any money out. Then supplementary grants, additional grants, excess grants. Supplementary grants means if your fund is insufficient. Let's say, for example, we are taking generally financial year, means here April, for example, you take 2024 to March 2025. This is the financial year, not January to February, that is calendar year. January to December, that is calendar year. April to March, April 24 to next year March 20, this is financial year. Let's say 100 crore is given to Ministry of Education. This is not sufficient, insufficient. So then supplementary grant will give government. Then additional grant, let's say some new service has to come. Let's say because of COVID, mask has to distribute government. This is a new service. At that time no COVID there, during when budget was introduced no COVID was there, but now new service has to give mask to the children. So this is the additional one, additional grant. Then the excess grant means you spent more. Let's say 100 crore it is given, but you spent already, it took 150 crore. Let's say one project is there, okay, one project, okay, for that 100 crore they thought, but it came as 150 crore finally, some because of some circumstances. Then this is excess grant you already made without permission. So after spending you have to take the permission of the Lok Sabha. Okay, so again this supplementary additional excess grant, anything will come again, like budget we have to make a statement, and president will cause this another statement, extra statement before the parliament. If it is that expenditure, that is supplementary additional expenditure. If that is excess grant, then Lok Sabha has to power. That is Article 115. So all articles will apply again for when you supplementary additional excess grants you are doing. Again Article 112 means you have to introduce statement. Then 113 you have to discuss, you have to introduce as demand for grant, discuss all that. Then 114 you have to appropriation bill, means for withdraw. There is account na, from if you want to withdraw you have to make parliament law. First you have to introduce that here statement, then you have to discuss it. So first to introduce 112, then discuss 113, 114 you withdraw. This all will apply again for this supplementary additional excess grants you are taking anything. Then vote on account, vote of credit, exceptional grant. Exceptional grant means similar to mask, you can say something that is not contemplated or not thought in the during the budget, during when annual financial statement is given, you did not thought that. Then votes of credit means there is unforeseen demand. Okay, it is like blank check. It is like a blank check. Let's say Pakistan invaded India. Okay, let's say Pakistan, some country came for war for India. We need some advanced weapons, let's say from USA or from Russia. Okay, we cannot wait for the 114 appropriation bill. Let introduce the bill, let pass the bill, then we will buy the weapons. By the time the other country will already attack with their weapons. So there should be some kind of blank check available. So in as part of vote of credit, it is like blank check from consolidated fund of India. The government can withdraw any amount. It is a very powerful thing. So this is only for unforeseen demand. When exigency is there, then only vote of credit. It is like blank check. The parliament can use it. Government can use it. Then vote on account means, for example, I told this is for financial year. So this is April to March. This is introduced. No, earlier what happened? Budget is introduced in March, let's say. Then for passing the Article 114 appropriation bill, it will take some 2 months. So for these 2 months, from where from money will come? They will pass the vote on account. So for 2 months, they will take some 1/6 of the amount. For example, let's say we want 1,000 rupees for a whole year. Okay, they will take advance here some, let's say 200 or whatever, 200 rupees or etc. It is like advance you take, advance money. Let's say you have to give you, let's say you have to give me 1,000 rupees. So in advance you will give 200, then in later you will give something like that. That is vote on account. Then here Article 113, 114 will apply when your vote on account, vote on credit. Then exceptional grants when you are doing under Article 116 class 1. Then article financial bills here. This is financial bill category 1 or category A. This is a category financial bill category 2 or category B. So here any provisions of 110 1A to F. Okay. Only provisions of 110 means that is money bill, or some provision, any provision of this plus some other provision is there, then it is financial bill category 1, and they need a recommendation of the president, and you cannot introduce it in Lok Sabha. Okay, you cannot introduce it in Lok Sabha. However, no recommendation of president is required if you are reducing or abolishing the tax. Let's say you are reducing, abolishing tax means it is doing good for the people. To good for the people, there is no recommendation of the president here. That is given. Then what is not a financial bill? What is not a financial? Same thing. What is not money bill we have seen? Any fine, penalty, fees or tax by local authority. That is not a financial bill. This is exemption given. Then expenditure, any bill expenditure involved to take from the consolidated fund of India. Okay. For example, let's take you are introducing Aadhaar. Okay. Plus to give Aadhaar to the people, you need some money. Okay. You need some money to take from the consolidated fund of India. Okay. Just a minute. So a bill is there which involves some other, for example, Aadhaar some bill, but this involves some money to be taken from the consolidated fund of India. Let's say to distribute Aadhaar cards. Okay, let's say you want some 1,000 crore also. So there is amount involved. At the same time, the bill there should be Aadhaar given to the citizen of India as a proof of residence. You should be given these details are there in the bill, plus some amount also involved. So this is what a financial bill category 2 or category B, and here recommendation of the president is required for the consideration of that bill. Consideration of that bill. So here what it says. First financial bill category 1 means any provision of the 110 definition of money bill is there. That is there. Plus some, it is not only provision. It is involved some of the provisions also in that. So that is a financial bill category 1 which requires, means here it will dominate. Money bill will dominate. Means 110 is dominating here. 110 is the provision of money is the main important source. Here money is not that important. Money is some sub part. Okay. So wherever category A means here money is more important. Here money is there but it is less important given. So that is financial bill category 1, category 2. For category 1, president recommendation is required. And then it should not be introduced in Rajya Sabha. It should be introduced only in Lok Sabha. That is House of the People. Then 117, 3, category 2. Or category B, financial bill. Financial bill. So 117, financial bills. Financial bills. So money bills means I told article 110. So financial bill category 1 means 1171. Financial bill category 2 or category B 1173. Then rules of procedure. For example, there is house for one class to govern one class only. There is rules. One leader should be there. No one should talk. Then they have to inform the teacher, and class should be function. Girls should be sitting this side. Like that, some proper rules are there. Everyone should come by time. If absent, you have to bring your parents. You should not be absent. So some proper rules. Everything will be there to govern the class itself. So similarly, for each house, how the procedure will be taken, for that also rules will be there, and each house will make the rules with respect to that procedure and conduct of the business means here work. Okay, subject to this constitution rules, any provisions are there, any laws are there. Until rules are made in this clause, whatever dominion of India means, that time Constituent Assembly was there. So during that time, whatever the procedure they are following, those will be applying. However, there may be some modification can be done. Modification can be done by the chairman or the speaker. And then with respect to joint sitting or communication between the two houses. Okay, two houses means here two houses are there, Lok Sabha, Rajya Sabha, Lok Sabha. Any communication is there. For example, I have to communicate to Rajya Sabha something, or I have to pass the bill. How I have to pass the bill? Through letter or through email, like that. Some communication how I can do, or joint sitting provisions. So with respect to that, rules who will make? President will make, but with consultation with the chairman or the speaker. Then joint sitting is presided by the speaker, that we know. This is given in Article 1184. Okay, let's say from question is contained. Joint sitting is presided by the speaker. Presided by the speaker is given in which article? Article 118. Okay, let's say Article 108, 118, 120, 130. So 118. 108 no. This is important. And in his absence, rules will decide. What are those rules means? In his absence, deputy speaker will be there, and in his absent, deputy chairman. In his absent, deputy chairman. If he is also absent, then rules, then house will elect. Then houses, okay, two houses na. So houses will joint sitting when two houses came and sitting na. So two houses will elect some person. That is 118. Then 119 financial business. Any procedure or any rule is there, so that parliament by law will create or by rule will make. This article empowers the parliament. Article 119. Article 20, language to be used in parliament. So parliament is there, means Rajya Sabha is there, Lok Sabha is there. So you can speak Hindi, you can speak English with the permission of PO, means presiding officer, speaker, chairman, or person acting such. You can use the mother tongue also, means your local language. Then English is stands omitted after 15 years. This is the case given in 120, but it is later changed. So now you can also speak in parliament English also. Then 121 means restriction and discussion in parliament. So means with respect to anything, conduct of the judge, you cannot speak in the parliament except during removal. Except during removal. Yes, you can remove the Supreme Court judge through Parliament Act only. So that is restriction. You cannot discuss the conduct of the judge in the Parliament except during removal of the judge. That is 122 reverse. So Supreme Court or High Court or courts, okay, courts cannot inquire the proceedings of the Parliament. Okay, for example, one MP is speaking like that, or one other MP is speaking like that. Courts cannot inquire. Okay, you should not speak like this. No, that is given clearly in Article 1. Courts, you cannot interfere it. So this is what separation of powers. Separation of powers means here legislature, executive, judiciary. Three wings are there in the government, parliament. In the government, three wings. Legislature, what it will make a law. It will implement a law. It will interpret the constitution or interpret the law. Implement law. For example, let's say 100 rupee is the fine. You're doing some X act. You're doing some X act. 100 rupees is the fine. This is made law. Now who will implement this? This is bureaucrat. Means government servants will implement. That is executive will implement. Then judiciary, whether they are doing properly, whether they are doing as per law, or whether law itself is the as per the constitution. So it will check both, whether they are following constitution or not, whether they are following proper procedures or not, whether everything is as per the act, as per the law or not. That is it, judiciary. Is guardian of the constitution. Judiciary is called guardian of constitution. Very important. Guardian of constitution. Which of the following is guardian of constitution? Supreme Court. Then Article 123, powers of the president to promulgate ordinances. Ordinances means actually when bill is there, Lok Sabha and Rajya Sabha, they are passing the bill and it is becoming the act after president signing. Let's say Lok Sabha is not in session. Now Rajya Sabha alone cannot make. Okay, when Lok Sabha in session, not in session, then no act can be made. Let's say Lok Sabha is also not in session, then also cannot make. Let's say Lok Sabha not in session, Rajya Sabha both are not session, then also you cannot make law. So there should be Lok Sabha, there should be Rajya Sabha, then only I can make a law. So when Lok Sabha is there, Rajya Sabha is there in session, then only I can make law. Let's say any one house is not in leave. Okay, it is not in session, not leave, when not in session, or both houses are not in session. Then if president is satisfied that there is a situation arised, then president can issue the ordinance. Means it is like a law only. Okay, it is equivalent to parliament law. Let's say I want to impose urgently the lockdown, then president will issue ordinance, lockdown ordinance from today onwards, like this. You have to follow these rules. If you violate, these are the fines. For foreigners, these are the rules. So such exigency, whenever there is urgency is there, but the houses are either house or both houses are not in session. This is what we call word during recess of parliament. During recess of parliament. Means parliament is not session, both or either house is not in session. Okay, if both houses are in session, then president cannot cannot promulgate ordinance. Promulgate means declaration, declaring, announcing. So this, if president is satisfied, there is some situation arisen, then president can issue ordinance, and it will have same force and effect as an act of parliament, no less, no more. Whatever parliament is having, parliament act is having power, that power it is having. Means police can arrest, everything can do as per the ordinance. Okay, after once the ordinance is issued, after now Lok Sabha, Rajya Sabha are coming, then within 6 weeks they should be put up before the house. Within 6 weeks these houses should approve. Of course, they may disapprove also. We don't want. Let's say ordinance is wrongly given, then parliament can disapprove this within 6 months. Or if they want to approve also, within 6 months they can approve. After 6 weeks. After 6 weeks, it will automatically, the ordinance will end. So the president may withdraw at any time also the ordinance. And then ordinance, whatever the parliament is would not act under this constitution, that will be void. Means here what is the meaning? Let's say parliament is not having power with respect to some subjects. With respect to those subjects, president is also not having power. So whatever the parliament is having to act with on those subject matters, only on those matters the president will. If any going outside, then that ordinance will be void. For example, president is making state list, subjects are there, state list subjects under Article 246. So under state list he is going and doing law. State list, who can make law? Only state legislature. Union cannot enter, center cannot enter, president cannot enter. If president is doing ordinance such that, it will be void. It is not valid. Void means not valid. So that is Article 123. So based on this, some inference, there is Cooper case given of satisfaction. This one, president satisfaction can be questioned on the grounds of malafide. Let's say if wrongly he is giving, there is no emergency, there is no COVID, but still he is imposing lockdown. Okay, then court can enter. Why you are imposing, Mr. President? There is no lockdown, nothing. Everything is proper. So why you are imposing? Let's say he is prorogue the house deliberately to impose the ordinance. If Lok Sabha, Rajya Sabha, if Lok Sabha, Rajya Sabha is there, they are not passing the bill. Then he will prorogue the one house. Let's say Rajya Sabha. Now Rajya Sabha is not in session. Now ordinance he can issue. Like that, if president is doing, that is unconstitutional. Then 38th Constitutional Amendment Act, or 38th Constitutional Amendment Act made it, this satisfaction is final. President satisfaction final. However, 44th Constitutional Amendment Act, it removed this final satisfaction. Then in DC Wadhwa case, in 1967 to 81, 256 ordinance issued in Bihar ranging from 1 to 14 years. This is violation of the constitution. That is what Supreme Court termed. Then these facts, remember, 6 months, 6 weeks is the maximum life of the ordinance. Because from one session to one session, there should be maximum gap 6 months only. So let's say Lok Sabha has not, this is the last session of the Lok Sabha. Then within 6 months, let's say here again Lok Sabha has come. Then once Lok Sabha has come, within 6 weeks, it has to approve the ordinance. Let's say here ordinance is issued. So this 6 months plus 6 weeks, this is the term. And then ordinance power is not discretionary power. Whatever COM says, that president will do. It can be retrospective, that is backdated. That is, I can give from 2021. The law will apply from 2021. Cannot amend constitution. Not found in most democracies, including US, UK. So only useful in exchanges is as per Ambedkar. Then the statement should be provided when bill is introduced for this ordinance, explaining circumstances, rules of Lok Sabha. Describes this, you have to explain the circumstances, what made you to put up this ordinance. Then 124, 147, there is one lecture, you can watch that. Then, so 124 to 147, Supreme Court. Then 148 to 151, this is COG. This is also explained. So Article 52 to Article 151, this is Part 5 of the Constitution. This is about union. Thank you.